Awesome. Well, welcome everybody to our Arvada Chamber Employment Law webinar. Obviously, there's so much to talk about in this session. A lot has changed for your businesses and especially in the HR space. And so we want to make sure that we are providing you a really robust update of what has changed. And we have an excellent speaker today that's going to help us unpack what those changes are through kind of an HR lens, as well as being an HR activist and advocate in our region and community, which we really appreciate that lens, because all of you know, and I see many of our Advocacy CAPS Council friends on this call, we know that the impacts on business when legislative changes happen are big. And so we appreciate the opportunity to come together with all of you and talk about what those are and how we all move forward productively and legally. So with that, couple of housekeeping items for today. You should have received notice that this is being recorded as you signed in, but we always appreciate the opportunity to be able to share these sessions far and wide because it is such important information. Because this is going to be a lot of content. I think Jeannie just told me 22 active slides of new content for you today. And we're going to ask that you put your questions in the chat so that at the end, we can come back and respond to those questions. And I promise we'll do our best to get through those at the end of the session. As you see, we are not in the traditional webinar format that many of us have gotten used to. This is a true Zoom meeting. And so monitor your mute because we can hear you. Ryan has officially been designated the mute police today. So if he sees you've come on mute, he's going to help you out. But we want to make sure that we're all able to maintain focus on our amazing speaker today. So with that, I am excited to pass the torch to Jeannie Valliere with HRx Services. She is an HR consultant and activist and is going to help us to really unpack and understand what's happened today. I keep saying that there needs to be an applause button on Zoom, and they have not taken my feedback yet. But Jeannie, we're so glad to have you here, and I'll let you take it away and tell us a little bit more about you, your business, and what we need to know.
Thank you, Cami, and thank you for everybody's time. I know this is what everybody wants to do at their lunch hours, talk about employment law. How exciting. I also want to add, I want to always put the infamous disclaimer. Everything that I speak about is from an understanding of HR compliance, best practice. I am not an attorney. I cannot provide legal guidance, so I wanted to put my famous disclaimer out there. Okay, and I hope everybody loves the title of my side. Goodbye 2023. We are done. It is officially 2024. Yay. And with that, we're going to have a lot to talk about. A little bit about myself. I am not originally from Colorado. I'm born and raised in Washington, D.C. I moved to Colorado in 2000, and I've had the opportunity and I felt very blessed to practice HR for the last 23 years here in the great state of Colorado. But with that comes a lot of fun. So not only am I an HR practitioner, I'm also a business owner. So I am talking to you not only as an HR consultant, but as someone who owns a business and understands how this impacts my business. I have 11 employees, so I know some of the challenges that everybody experiences. Lastly, in addition to running a business and being an HR practitioner for the last 33 years, I do a lot of volunteerism in HR. I'm on the state council for the Society of Human Resource Management. I own the Disrupt HR license for Northern Colorado, and I am in my third term as a judicial review commissioner appointed by Governor Polis for the 19th Circuit Court here in Northern Colorado. I do performance reviews on judges. So when you read the blue book, read it. We actually do something with that information. Okay. So we have a lot to learn. I do want to take a step back in time and talk about equal pay for equal work. I realize it's a pretty belabored subject for small business, but there's a reason. So hopefully you'll be patient and understand why I want to bring it back to the surface. Additionally, I want to talk about a small recap of 2023 compliance things that happened. Some are notable and super important to have a better understanding because typically, and I think as chamber members, you may be aware that when our legislators pass things, generally they wait to the following calendar year to implement these changes. That is not the case this past year. They implemented several employment law changes in 2023. and immediately appropriated a significant amount of money to these labor law changes. Lastly, we're going to talk about 2024, and then I like to kind of round it out with what I call my legal update timeline, what to expect when you're expecting legal changes. Okay, so equal pay for equal work. Real quick, what do we already know about it? Which is basically all jobs have to be posted. There has to be a salary range. It bans pay disparities on the basis of sex. Keyword sex. I say that because the EEOC published an article today that a male just prevailed in a federal Equal Pay Act violation. It is based on sex. Generally, women tend to be paid less than men, but there are cases where men are paid less than women. So it requires not only are the positions to be posted, salary ranges posted, but general benefits. And lastly, the disclosure of any opportunities for promotional growth opportunities in one's company. So that's been in effect since January 1st, 2021. We've been doing it. I'm okay with it. I really am. I know at first I resisted it, but I'm okay with it because it cuts down and makes the recruiting process a lot easier. I know what they want. They knew my salary. But there's been some crazy things that have happened to it, both on the legal side and the claim side, as well as the employment law side. So let's kind of talk about that. 2023. Anybody familiar with Ames Community College? No, yes. Community college, it's actually the most affordable community college in the state of Colorado. It happens to be based in Northern Colorado, but it has campuses in Fort Collins, Greeley, Fort Lupton, Loveland, Longmont. So it has a little expansion. Well, interestingly enough, Ames Community College, which sadly, I'm an adjunct professor and I teach HR classes there. But that being said, they settled two lawsuits for two former vice presidents, combined compensation payout total of $950,000 for women who had filed harassment, discrimination, and equal pay violations. So it's real. And the interesting thing about this particular claim is this is an educational institution. They know the rules. They have a whole bunch of people teaching the law. They are also funded by the state of Colorado. So they fall under kind of a public municipality since it's a state school, and they broke the law. And it was interesting because the attorney who defended these two women, Miss or Mrs. Riley, I can't remember. She is making a name for herself defending a lot of women and advocating these claims. And she said, and I quote, all boats rise to the tide. She is going after employers to make them pay. They want to ensure that employers are paying substantially similar work equally based on sex. So I brought this because I think it's local. It just happened this year or this past year. It is the largest single payout under the equal pay since it was implemented in 2021. And it should also be noted, it was the quickest litigated claim under equal pay. Okay, so real quick recap for 2023. Back in 2023, minimum wage was $13.65. 50,000 was the annualized salary exemption, which equates to $961 and some change on a per week basis. And I hope everybody realizes that if you have an exempt employee, they must in 2023, they must have earned at least 50,000 and met the duties test to be considered an exempt salary employee. If they did not, you have a misclassified employee and you have a whole different mess. The Proposition 118, also known as FAMLI, FAMLI, which is the Family and Medical Leave Insurance Program, which is been branded as a entitlement program similar to unemployment, went into effect January 1st, 2023. Deductions were being made from paychecks. It was in the summertime that the family division ruled that you could set up a private plan. So private plans were being quoted. There's a lot of list things here that happened. These are all the actual employment law changes that took effect in 2023. The last one is the most important one, as $1.2 million were immediately appropriated to this change. It's called POWER, Protecting Opportunities and Workers' Rights Act. Senate Bill 23-172. It's probably the single most significant legislation currently, and I say currently, in the lower 48. Yeah. Okay. So right there, hopefully I got everybody's attention. This particular piece of legislation provides certain protections to employees and certain responsibilities to employers that we don't even see in the state of New York or California, which are very typically heavy oriented employee friendly states. Again, and by the way, this is not about any particular politics or where I sit personally or professionally, but it goes without saying that if you practice HR in the state of New York or California, it is generally designed to benefit the employee in those states. And it has become very cumbersome as an employer to do labor law in those states. This particular piece of legislation is much more significant than any anti-harassment legislation that is required in, I believe, currently 6 states, California, New York, Illinois, Massachusetts, and there's 2 others, Colorado and one other one. But this one in particular, it has some interesting nuances. So we're going to dig into it a little bit more. Okay, some of the other updates. This particular form that you see on my screen, while the notion of it is new, i.e. the form, and the form is new. It came out in 2023. The requirements for everything contained within this form have been in place for the last couple of years. So if you were an employer, you already had the responsibility to provide all of this information, i.e. employee's name, social, start date, hire date, in some form of a written letter to the employee as they exited your organization. This is not new. Unemployment was amended a couple of years ago that made a requirement to employers to provide employees the right to be aware of their opportunity to apply for unemployment insurance. This actually came out during COVID. So this particular form, the CDLE came out and said, you know, employers are struggling to concisely consolidate this information consistently in an exiting letter. So we're going to create a form and you can use this. You're not required, but you can use this in lieu of anything that you had previously created. So this particular form, whether you use it and give it to an employee, the content contained therein in the form has to be given to every employee who leaves your company, regardless of how they depart. Meaning, if they resign, you lay them off, or you terminate their employment, you are required to give them this information. Everybody know that? I didn't think so. Most people don't. Interesting thing about this is this year, I don't, maybe this year, and I shouldn't say this because this is being recorded, but I feel like this year is the year of, hey, we put all these laws in place, i.e. equal pay and some of these other things. And I feel like, and then I have no basis, but I feel like the CDLE is now really looking to come down on the compliance side and really start to hold employers accountable. And by that, I mean, I had an employer client that I work with that recently had an employee go to file unemployment. And the UI intake officer said, hey, where's your form? Oh, pardon me. Where's your form that provides all this information? And he goes, I didn't get anything. And they said, well, where's your exiting or your termination letter that provides all the tax ID and the employer's legal name? I didn't get anything. The employer got a letter from the unemployment division as a warning that if they didn't start providing it, they would assess fines and penalties in the future. So if you don't do it, make sure you're doing it. Okay. Power, to have it or not to have it. That is not the question. Here's the thing. Power is, it is basically a law protecting the opportunity and worker rights. It expands the definition of harassment to include any unwelcome conduct that explicitly rejects judicially created severe and pervasive, i.e. the standard of proof. What does that mean? Well, if I asked, and I just quickly looking at the people on this call, there's a lot of females. If I said Harvey Weinstein, at least shake your head. Does everybody know who he is? Yep. You want to know why? Because we meet the reasonable person test. We read enough, we heard enough to know this man was a predator in the workplace, and therefore he met the definition of what we consider a reasonable person test. He violated many a sexual harassment laws, many. Okay. Now, fast forward to power. Take Harvey Weinstein out of it. I'm an employer, and nobody has to share this, but think about whether it's a business now that you own or a business that you've worked for, or any time in your career or professional history. Did you ever work with a supervisor who was referred to as that supervisor? Meaning, they were really good at their job, but their interpersonal skills were marginal at best, but generally they were a jerk. They treated people poorly, they yelled, they screamed, they were micromanager, they just basically were not a good human being. But as an employer, often they tolerated bad behavior. Why? Because they did their job, the technical piece of their job well, and thus they tolerated the bad behavior. Now, consequently, a lot of people would quit because of said bad boss, or, you would often hear, well, that's just how they are, or that's just the way they behave. Just deal with it because they're irreplaceable. I heard that so many times. And I'm like, no, everybody is replaceable. Everybody. That being said, this particular law does not tolerate that supervisor. And so it's super important to understand that supervisor, those behaviors, no more, won't be tolerated. Why? Because the reasonable person test has been redefined. It is now called subjectively offensive. So, reasonable person could be 8 out of 10 people thought Harvey Weinstein was icky. Why? None of us were those women, but we read, we heard, we listened, we said that type of behavior is not appropriate. Reasonable person. Now, subjectively offensive is I am one individual and that supervisor says something inappropriate. I find that subjectively offensive. Guess what? Employer, you are now on the hook for a violation of Colorado's new anti-harassment laws. And here's the thing, you have no affirmative defense because you cannot any longer tolerate bad behavior by that supervisor. Because if that employee found it to be subjectively offensive and violated any portion of power, you'll be hard pressed to defend it. Now, there is some comfort, maybe, I don't know. Interestingly enough, Colorado is one of the few states where a supervisor can be sued individually right along with an employer or a business or an entity. So, supervisor who has been a jerk also could be sued, but that doesn't really help you much because your employer's liability insurance is going to skyrocket to have to defend said jerk because one person, and I did this training and I don't in any way, shape or form intend to offend anybody. But here's what an attendee of one of my trainings said. So he said, and I quote, he goes, well, if they're a snowflake and they can't deal with that supervisor, how is that my problem? And I said, it is your problem. And they're not a snowflake because the word subjectively offensive is also very subjective. And so he looked at me funny, maybe not, but he raised his voice. He pointed at me. It's going to meet the litmus test and you're screwed. So don't tolerate bad behavior. Okay. So power has amended 5 key areas. First one is it added a protection to our current Colorado Anti-Discrimination Act. It added protections for marital status. How many of y'all ever worked 10 years ago and you heard about this policy that if 2 people were dating and they got married, one of them had to go because we couldn't have 2 people married in the workplace? No longer. Power has basically said, no, marital status is a protected category in the employment context, and you cannot alter someone's employment just because they get married. And it is what it is. It lowers the standard, and I want to say it truly lowers the standard of unlawful harassment. The act specifies the totality of circumstances, includes frequency, duration, location, conduct, the number of individuals, the type and nature. Is it subjectively offensive? That's a lot. Additionally, it adopts new record keeping requirements. This is a big deal, not necessarily like, oh my gosh, you have to go hire someone from an administrative burden financially, but it places an obligation on the employer to preserve employment records for a period of 5 years or the latter date if an employee files a complaint. And it says it has to be in a separate depository of anything relating to a power claim. So that could be harassment, discrimination, termination because I said you were married and I don't want married people working together. It could even be about disability, and I'm going to talk about that. The term personnel or employment record includes anything: requests for accommodation, written or oral complaints. Oral, that's going to be an interesting one. I said I've been doing this 33 years. I am what we call an unconventional HR practitioner. And by that, I mean, you know what? Sometimes it is what it is, and there's employee drama, and my affinity to listen to it is pretty low. And so I can recall years ago, if I had an employee come to me and said, you know, my supervisor is discriminating against me because just because I come into work late, they won't give me the schedule I wanted. I'd be like, well, you know what? That's called you didn't show up on time and you don't get the schedule you want. There's no discrimination. But guess what? Fast forward now with power, they use the word discrimination. I have an obligation, a fiduciary obligation to my employer. I have a requirement under power to investigate this. I have to investigate it because an employee has claimed discrimination in some form or fashion. You didn't have that requirement before as a business owner, or as a leader. You had some discernment to say, there's just drama happening here, or, you know, I know the full scope of things. You don't have that discernment now. You have a duty to investigate every claim verbally and in writing. Okay. Submitted job applications. I had a client just recently, person applied for a job. They were in a wheelchair. They went in for the interview. They said that, you know, everything went well. They connected. They thought this is it. Employer came back and said, yeah, we're not going to hire you. And he said, well, it must be because I'm in a wheelchair. And they said, no, not at all. It was because of X, whatever X was. But because they had gone through the application process, the interview process, he felt it was subjectively offensive how the interview went. There were a couple things. He came back after post not offering job when they thought it was perfect. And now the story had changed a little bit. Things just get different. Any records relating to hiring, promotions, demotions, transfers, layoffs, termination, rate of pay, in terms of compensation, selection, training, and apprenticeships. Records of training provided to or facilitated by the employer. So, interesting thing about this new power law, it doesn't say, it says that employers are supposed to create a program to deter harassment in the workplace. They have to comply to all the requirements of the law. It does not say that you're required to provide training, but it does say you're required to provide a program to deter harassment. So there's a certain level of ambiguity right now. We are waiting for the CDLE to kind of what we call give an info notice and kind of get better guidance on the law. The law was passed at the end of whenever the legislators end June, went to the governor. It was 2 days before the expiration of the bill. He eventually signs it, and then they immediately implement it August 7th. This law became law August 7th, 2023. So anything that happened after August 7th, 2023, you are on the hook for now. Lastly, it amends disability, or second to last, it amends disability provisions. So basically it is if you're subject to the American Disabilities Act, it basically it requires employers to engage in the interactive process. But what this particular law does, it loosens the standard and provides not only that there is no discriminatory practices on behalf of the employer that would create any adverse employment action, but that there is no reasonable accommodation the employer can make with regard to the disability to allow the individual to satisfy the essential job functions. And the disability actually it has to disqualify them now for the job. Before, we could just say, hey, is it a burden to the employer? We can't make these reasonable accommodations. I'm sorry. And that was part of the interactive process. This has said the disability actually has to disqualify the individual from the job, which I have to guess that this is going to get litigated against ADA because this is in somewhat direct conflict with ADA. But it's too soon to say, but that is what the current law says. And then lastly, it places limitations on non-disclosure agreements. The new law restricts non-disclosure agreements for any alleged discrimination exceptions. In other words, employees can't be forced to waive their rights for discrimination. That is not new at the federal level. They're just affirming it at the state level. That's a lot, I know. Okay. So how does an employee establish a claim? It's pretty simple. They pretty much have to go to their supervisor verbally or in writing. And if the supervisor doesn't have the following, they won't have a defense. Okay. So what they should have in place to be able to defend themselves against any claim is they have to basically say they have a program that is reasonably designed to prevent harassment in the workplace. They have to deter future harassers, and they have to protect employees from harassment. So if you have those three elements, you should be good. But understand those are very broad, especially protect employees from harassment. That takes me back to that supervisor. You can't tolerate bad behavior. That's not protecting your employees from harassment. If you tolerate the bad behavior, you did not protect them. Therefore, you do not have an affirmative defense. You can't come back and say you didn't know, unfortunately. You have to take prompt and reasonable action and investigate and address all alleged discriminatory and unfair employment practices when warranted. And it has, whether it's communicated verbally or through email, through text, you as an employer need to be a lot more cognizant of what it looks like now because it's subjectively offensive. Okay. Employers will no longer to be able to assert that otherwise, a qualified individual with a disability has a significant impact on the job. Because currently, right now, CATA, which is Colorado Anti-Discrimination Act, says if it has a disability that significantly impacts the job, that's a reasonable reason for an employer not to engage in the process. They are removing that. The employee has to be disqualified. Harassment that occurs that is deemed intimidating, hostile, subjectively offensive, or creates an environment such as subjectively offensive or I'm trying to think of the exact verbiage in the law, but at the end of the day, intimidation, hostility, or offensive behavior in the workplace, zero tolerance. Okay, so why does any of this matter? Well, at the end of the day, power pretty much is in effect right now. Because of the nature of the totality of circumstances and the various factors listed in the statutes, if you do not immediately review your handbook, review your policies, if you don't take your duty to investigate immediately, if you're not proactive in providing training, and if you aren't that employer that has a zero tolerance, you will be very caught off guard by this particular bill. And it will be very expensive and it will be untenable and unmanageable in the workplace. So if you put those processes in place, you should be good. I highly encourage, if you don't do harassment or discrimination training, do it now. It's not required, but do it now. Be proactive. That is going to be a part of your affirmative defense. Okay. Whew, a lot. I know that was a lot. Power is a lot. So now we're going to plow through 2024. What's next? Here we go. Okay. Minimum wage, Colorado, new current minimum wage, $14.42. If you have tipped employees, if you have any type of restaurant or hospitality industry, it's $11.40. A lot of revisions took place in 2023 regarding tip employees, tip pooling. I highly encourage, if you have tip employees, look at it. Denver minimum wage, wait for it, $18.29. I believe it is the fourth highest in the nation. Edgewater, I don't even know where that town is. I feel like it's west, right? I don't know. $15.02 is minimum wage in unincorporated Weld County, $15.69. So why is this important? Why am I telling you this? Well, Colorado legislators about 6 years ago passed a law allowing municipalities and townships and local counties regulate their own minimum wage. This is important because up until last year, it was pretty much the state of Colorado and Denver. That was it. The purpose of that law to allow local municipalities change the minimum wage was twofold. It addressed Aspen and Vail and some of those higher cost of living areas to raise the minimum wage to kind of help facilitate a better standard of living. But secondly, when you have employers who have employees working in multiple jurisdictions or geographies within the state, they are required to pay those minimum wages. So for example, if you happen to be doing business in Arvada, but your employees are working in Denver, you have to pay them the prevailing minimum wage of Denver. It's where the work is done. Okay. That's an important one. Salary exemption. So I think it was in 2012, the Colorado Overtime Minimum Pay Standards Order was amended, and it basically had an auto escalation for the hourly wage. It took us from the standard, I think it was like $8 or $9 an hour, and it auto escalated until it topped out at $12 a couple of years ago, and then it has been tied to what we call the Consumer Price Index and escalates year over year tied to inflation. Well, it was ironically right during the pandemic. It was comps order number 35. They changed the minimum wage for an exempt employee. So it immediately mirrored whatever the federal was, which was 38,000. And then that following January, it went up to 45, 50, and now it's at 55,000. That's $1,057.69. If you are not paying your exempt employees right now that wage, you have a problem. And you should audit all your compensation very quickly. But that's only the first part of it. The second part is the duties test. They have to meet the essential job function duties to be considered exempt. Our current federal administration is really cracking down on misclassified employees, both from the 1099 independent contractor as well as FLSA, which is exempt and non-exempt. Basically, they want the majority of the workforce to be hourly non-exempt employees because why? They get paid overtime, and that why is more tax revenue to the federal government or to whatever agency. Okay, so those are minimum changes. If you haven't done this, your employee handbook should have a copy of this in your employee handbook. It is required by law. It should also be posted somewhere. And it even says it right here. Now, ironically, this comps order doesn't always change from year to year, even if the minimum wage does. It has to have fundamental changes, i.e. different rules get updated and things like that. This is not new where it says employers must include a copy of this poster or the actual comps order, which is, by the way, 20 pages in any employment handbook or manual. That is not new. That was always buried in the comps order. Employers just don't read the comps order. They just look at the posters or whatever they're told by their HR people, this is what you have to do. Moreover, this particular poster has to be displayed and easily accessible when practical. Now, if you have remote workers, you have to provide it to them. You have to email it to them within 1 month of employment. And anytime there's changes, you have to give them an updated comps poster. This generally is updated in December. Um, I highlighted some things because these were notable things. Vacation pay, departing employees must be paid all accrued, unused vacation, including paid time off usable for vacation, without deducting or declaring forfeiture based on cause or for termination, lack of resignation, all of that. That is not new, but again, they've just updated the poster to make it very clear for employers. Additionally, this one is interesting, deduction for pays. There's a whole section under comps order about what's called permissible deductions. You can't deduct something from an employee without their written consent, other than statutory deductions, federal withholdings, state withholdings, family, even benefits you can't deduct without them signing off in an open enrollment form or an online benefit administration. However you do it, you need to have an agreement saying, I am taking something other than statutory tax deductions. Now, why would I deduct something? Well, maybe you advanced vacation, and now they're quitting and they owe you $1,000. Here's the thing, you can only deduct or recoup whatever you were owed to the point that it does not take them below minimum wage. Again, not new. That's been 20, 30 years. Well, it's actually been since 1938 at the federal level, and it's been longstanding whenever comps orders were created in Colorado. So if you don't have this poster, it should be hung and it should be in your employee handbook. Okay, so you have a pandemic, you have COVID, crazy stuff happens, and then you put before the voters paid sick leave. So we've all been navigating, paid sick leave. I don't need to go into it a whole lot, except everybody should be offering it in some form, whether it's a separate sick leave policy accrued at 1 hour for every 30 hours worked. If that employee terminates and you rehire them, whatever at the time of their termination, they are restored their original balance if it's within 6 months of termination. That's part of the law. They get 48 hours a year. Yes, it carries over. So for example, if I had an employee who never used any sick time for the entire year, and you have to carry over on January 1st, 48 hours, here's the thing, you don't have to accrue or add to that 48 hours. They only earn and use and cap and carry over a max of 48 hours. So if they used 40 hours and they carry over 8, they can only accrue an additional 40 hours in the following year. Clear as mud? Great. Okay, now it's changed a little bit. So public health emergency ended in June, thank God, no more COVID sick leave, or as a lot of employers refer to it as a coronacation. I.e. they got 80 hours and there wasn't a lot you could do, there wasn't a lot you could ask for, but you had to pay it. Well, that's ended. But understand, if the state had declared another public health emergency, it starts over and we have to deal with that 80 hours again. Understand that 80 hours is not per year, per occurrence. It is through the duration of any public health emergency. Okay. So what are the changes in 2024? Well, the legislators recently amended to say that healthy family workplace sick leave can now be used for some additional items. Understand, and if you didn't know this before, you can't ask for a doctor's note until after 4 days have passed. And I don't know if you know this, if you read deep into the Healthy Family Workplace Act, an employee can write their own doctor's note. It can be in their own handwriting. Well, fun nuances. But what is it expanded for? The care of family members whose school or place of care, daycare, preschools, is closed due to inclement weather, loss of power, loss of heat, loss of water, electricity. As a result, the family member can't come to work to take care of said family member. The other reason would be to grieve, attend a funeral service or a memorial, or deal with financial or legal matters that arise from the death of a family member. Okay, here's the fun thing. They did not define what a family member was. Good luck with that, navigating that. They did not define specifically what a family member is. Man, there's lots of chat questions. evacuate the employee's place of residence due to inclement weather, loss of power, heat, water, unexpected occurrence event that resulted in the need for the employee not to be in their home. Kind of weird to me, because if I lost power and I'm going to work, they have power, but because I don't have power at home, I don't have to go to work. That's basically what the law says. This is now in effect January 1st. So we are dealing with that one. If you haven't updated your handbook, make sure you add it to it. Next, let's talk about family. So family, we spent the entire year of 2023 collecting family premiums. And I just included the kind of one of their recent poster updates. But what they didn't tell employers was, on January 1st, 2024, guess what? So as people are applying for family for different things, if I had a child in 2023, let's say February of 2023, on January 1st, 2024, I can apply for family and take the next 12 to 16 weeks off paid under family for a child that I gave birth one time, meaning there's a one-time exception in 2023. The purpose of that was the state said, well, we need to do this because it's not like the employees, we had to fund the coffers before they could take the time off. So we spent the whole year doing that, and now they can apply for it. So this is just a one-time exception. So that means, so for example, if an employee of yours had a baby in 2024, they can't come to you in 2025 and say, I'm taking time off for something that happened in 2024. That is not what this is about. It is literally a one-time exception. Family can be used for parental bonding, that's mom and dad, medical leave to care for yourself, medical leave to care for a family member, military family member, exigency, and safe leave under the domestic abuse laws. I want to say, interesting thing about family, they have a pretty expansive definition of what family is under family. So, and I want to clarify that to say, under FMLA, the Family Medical Leave Act, at a federal level, they clearly define what a definition of adoption and parent in loco tenens and birth mother versus different things. They say mom, dad, children. They define very clearly what immediate family is. That is not the case. It's much looser under our family. So if you are currently, and I'm actually going to kind of jump to the next slide, if you are an FMLA employer and family, there are some remarkable differences between the two. For example, job protection. Under FMLA, you have had to have worked for the employer 1,250 hours in 12 months. Under family, you just had to have earned $2,500 in the preceding year. That's it. Now, if I want to be required to hold a job, the employee had to have worked for me 6 months, and then I have to hold their job. As opposed to FMLA, it's 12 months. There's no hours requirement under family. It's just 180 days. There's there are some similarities between the two, but I have to say, I feel they're pretty remarkably different. So if you feel confident and comfortable under FMLA, you're going to feel a little uncomfortable under family. But here's the interesting thing about family. You as an employer, if you are paying your family obligation to the state of Colorado, there's nothing you need to do. They handle everything. The employee goes to them. They don't even have to notify you. They are not, they're encouraged under the law, but they do not have to notify you. They go to the division of family, they apply. Family division, I believe, has up to, and please don't quote me on this, I believe it's up to 2 weeks to notify you, the employer, through the portal that an employee has applied. They are reviewing and adjudicating their claim, and they will then send a letter saying, you know, what the expected duration of time off. They will get doctor's notes. They will ascertain the med certs and all. You don't do any of that. You can't ask for any of that. You don't do any of that. You're not responsible for any of that. As opposed to FMLA, it's very different. Here's the other thing with family. You cannot have or require an employee to have like a waiting period. Under FMLA, you can say you require them to concurrently use their sick or vacation while they are taking time off. Because FMLA is unpaid, but because family is paid by the state, you cannot require an employee to use healthy family sick leave to make them whole, any portion of it, if they're using it intermittently or otherwise. Actually, you can never require an employee to use their sick time. You have to highly encourage you to ask them if they want to use it, and you should document when they choose not to, but you can't require them to use their sick time. Okay. I will try to remember, and I'm sure Cami will remind me. I will send this slide. We actually, for our clients, we give this out. What are the differences? Just to kind of, if you're in an FMLA mindset, how to compare and contrast the two. Okay, so next slide, a little bit more about family. Very quickly, family, it starts, or it's already started. Employees are already getting, they've been inundated with claims. But if you have a private plan, do you have coordination of benefits? So in other words, you should have already applied to the state, gotten approved, notified them who your private plan was, applied to get any monies back that you've already paid in. And then you should update your handbook, because your handbook has to clearly denote that if you have a private plan, who it's through, what that process is for applying for it. The reason why you have to update your handbook is because otherwise, through the CDLE, you have required posters that you're posting in break rooms, but you don't have to post them if you have a private plan. So you then have to provide that supplemental information somewhere for them to know how to access the family monies that may need. And then you should highly consider what's called a coordination of benefits policy or agreement. Because the way family is designed is you get up to a percentage of your disposable income. So you could potentially get up to 90% based on how much money you make. So they have a calculator on their website. But here's the thing, how do you coordinate if you offer short-term disability? Or maybe your company has a paternity or a maternity policy that already pays for 2 or 3 weeks or 4 weeks. So you should be able to forecast the coordination of other leave benefits and other medical benefits that may work with family. So something to think about. Okay, just a couple of other things new. And in this is good timing. Cami pushed to get this done as quickly as possible. Good for her. If you didn't notice, you are legally required to provide this notice to all employees this year. This starts effective January 1st, 2024. So when you're doing W-2s, depending on how you do them, if you do them paper, then if you go down right here to this URL right down here, I think it's this one, or yeah, it's this one. You can download the notice. It there's another attachment. I only have one out of the two there. There are two that you're required. It has certain size requirements, certain this, certain that. But at a federal level, this is kind of dovetailing to the earned income tax credit that is available to some employees. Now, Colorado passed a law saying, hey, employers, you have to give this to everybody. While most are not eligible for this earned income tax credit, you still have an obligation to provide it. So here's what I would do. They allow for electronic dissemination of this. I would just make sure that you already have a policy in place that allows you to communicate policies and procedures electronically. I would send it return receipt if you're going to do it via email. If you're going to drop it in the mail with W-2s, that's good too. But don't forget to send it. It is required and new this year. Okay, Colorado strengthened the pay transparency law. So this is a dovetail to equal pay for equal work. The portion of equal pay for equal work that requires wage information to be posted. So this part of the law, as we discussed in equal pay, which took effect in 2021, the disclosure pay range in all job postings online and any promotional opportunities. Now what's done is they've amended the law to say not just promotional opportunities, any internal job opportunity has to have a posting and a pay range. So it existed to the previous requirements for the pay range, description of benefits and the job posting, so on and so forth. Now, any employer, now, if you have 15 or fewer employees, you don't have the same posting requirements until July 1st. I think it's 2029. So you still got a ways, 5 years. But if you have more than 15 employees, everything has to be posted. Now, they did do a nice little explanation and said, hey, if you, let's say I'm a HVA, no, I'm an electrical company, and I hire an apprentice electrician, and I know over the course of 1 year employment, they're going to go from apprentice to electrician to journeyman. That is part of the progression of their career as part of the first year of employment. I don't have to post each job as they move from different pay rates and different job titles, because that was redefined in this pay transparency. But here's the other nuance. Now, this is usually where I get a lot of pauses and facial expressions. As you promote people now, within 30 days after selecting a candidate, you are now legally required to provide the following information to all employees in your company. And that is who you selected as the candidate's name, the candidate's former job title, if the candidate was an internal hire, the candidate's new job title, and information that could allow employees to be able to demonstrate their interest in future or like similar jobs. In other words, if you posted a customer service manager and you promote a CSR, you have to provide their name, their former job title, their new job title, and how other applicants or other employees in your company can learn on what skills is needed for that customer service manager role for the future. All employers are required to do this effective January 1. If you have less than 15 employees, not till July 1st, 2029. I take that back. I strike that. The July 1st is the pay and the remote workers, the posting of jobs for remote workers. You have to notify all employees of who you selected. Now, there is a provision that if the employee whom you promoted comes to you, and you have to be able to prove this, by the way, comes to you and says, I don't want anybody to know that I got this job, or how, whatever their reasons are, if they feel it's a privacy issue, they do have the right to ask the employer not to post that information under certain privacy laws, but they have to notify you. And then if an employee learns that someone got promoted, you didn't post it, you have to be prepared to show that paper trail that that employee said they didn't want their information shared for privacy concerns. Okay. This is an interesting one that takes effect July 1st, 2024. And basically, this particular law, basically now, if you have a job application, a lot of times we ask, what year did you graduate from high school, from college, from trade school? That needs to be removed. Anything on a job application that could denote a year of something that could potentially tie back to an employer to start doing, well, you got to be 18 when you graduate from high school. So it's 2024 minus 1986. That's when I graduated. She must be X years old. So that has to be removed effective July 1st. So you have some time. You already can't ask whether somebody was previously incarcerated. You can't ask about felonies and convictions. You can't ask about age. You can't ask about former compensation. And now you can't ask about a year of graduation. The next thing, this is a federal, and I know today we're talking about Colorado employment, but I want to put this on everybody's radar. And this is kind of important. The difference between non-exempt and exempt employees. I feel like most business owners know that. The salary threshold is currently being reviewed at the federal level. Right now it's at $35,568, which is lower than the state of Colorado at our $55,000. That being said, the federal is looking to raise it to $55,068. So then that puts it higher than Colorado, which means a whole bunch of employers, if they had somebody exactly earning 55,000 to be exempt in the state of Colorado, they'd have to immediately give them a $68 a year raise. So just be cognizant. We should know more by the end of Q1 if this comes to fruition. If you remember back in the Obama administration, it got shot down. And then now it's being looked at again under the Biden administration. Okay, I am close to the end. Colorado employment law updates and pending changes. So we talked about comps order 39. We've talked about the overtime minimum pay standard order, also known as comps. Have it in your handbook. Make sure your salary exemptions are on point. Family, people are applying for it. If you haven't set up your family account, make sure you have. They lowered the overtime threshold starting January 1 for ag workers. Colorado restricts the age-related inquiry starting July 1. Whew, okay, I have 4 minutes to spare. What questions do we have?
Awesome. Thank you so much. You did a lot. You covered a lot in our time together. So thank you for that. There were a number of questions in the chat. So I'm just going to work through these and we'll see if we can fire around the questions. Starting with one from Christine, and this was going back to the unemployment insurance form. How much time do they have to provide the notice to the employee?
That's a great question. I honestly, I'm going to be very honest. I don't know, but what I believe I read is it has to be at time of termination. So in other words, if you had someone who gave 2 weeks notice, you could give it before, but it has to be at least time of termination because they can file electronically online for unemployment and they need that information the next day.
Thank you. Next question related to power. The term fiduciary responsibility was used when talking about power. That term means something different in different contexts. Was that word fiduciary stated and defined in the legislation?
No, but here's my context for using it. If you, and I use that word specifically for this audience, under the notion that you are officers and owners, there is a fiduciary in your employer's liability insurance. When you sign your EPLI, you take on a certain risk and responsibility as an officer of the corporation, company, LLC. It is not, there is not a fiduciary responsibility for general leaders, managers, supervisors. There is not. This is more directed to anybody who would be an officer or owner of an organization.
Great. Thank you. I know we're fire rounding here. Thanks for rolling with us. Are there any exemptions for small businesses in power?
None.
None. Boo. Okay. Next question, clarifying that you said if they're a Nevada-based business, but they have hourly employees working events in Denver, do they have to follow Denver minimum wage?
I would have to look into that a little bit more because I assume an event is a very short duration of time. It's probably potentially something hospitality driven. I don't want to answer incorrectly. I would have to investigate that more and I'd have to read the Denver order a little more in detail.
Okay, thank you. We can see if we can gather that, maybe work together to figure it out and we'll share. And then employees, can they use both family and FMLA benefits?
Concurrently, yes.
Okay. Can an employer discontinue paying short-term disability while on family?
You should talk to your insurance broker. I don't think so, because typically you enter into a contractual relationship with your provider for short-term disability. But again, that's more your broker. I would ask your broker.
Okay. Next question is, if you post all job opportunities and let all employees know, do you still need to provide the new information if there is an internal hire?
Yes.
Okay, great. Transparency, if your company is totally remote, do they need to post every position, and if so, where?
This is a tricky one, and they're in the info guides. They give a lot of examples regarding remote workers. If you go out to the CDLE's website, they literally have multiple examples specifically to this question. It's not a cut and dry answer. Remote workers, COVID became a lot more complex. So is the remote workers based in Colorado versus another state? Where do they do their work? It becomes yeah, I can't answer that specifically, but what I would tell you is if you're totally remote, you should be providing whatever state they reside in, the applicable labor laws, and that's typically what governs their work, is the state they live and work in.
Okay, awesome. We didn't get to everything, but we are at time. Thank you all for being so engaged and asking such great questions. I will offer to all of you, we do have a really active advocacy group here at the Arvada Chamber, and we're always looking for additional partners, especially in the HR space, to help be part of these discussions. So if that's something you're interested in joining, please reach out to me. I'll drop my email in the chat. Actually, I'm going to ask Molly to drop my email in the chat while I'm talking here and closing us out. Please send me a note. The other thing that I would love to have you all sign up for, we launched a new advocacy engagement software to really make sure that as these new policies are being enacted and considered at the state level, that we're giving really good business impact feedback to our elected officials. So if you're willing to be one of those businesses that will share impact with us, let us know. I will also just kind of mass send out to all of you a link to opt into that so you can be connected to those opportunities to testify and provide stories of impact, because as you hear, all of the things that happen at the state capitol do impact our businesses, and it's important that we stay connected as a business community. Again, another big thank you to Jeannie. Amazing content and a lot for all of us to think about. We appreciate you very much. And as always, the Arvada Chamber is here for you. If you need anything, please don't hesitate to reach out.
Thank you.
Bye, everyone.